Pattie Gonia is publicly challenging a lawsuit filed by outdoor apparel company Patagonia, claiming the legal battle could cost her more than $1 million in fees and threaten the future of her drag identity. The activist and performer shared her frustrations in a lengthy social media statement on May 28, arguing that the dispute goes far beyond the symbolic $1 in damages requested by the company. According to Pattie, the real issue is the attempt to prevent her from using the name she has built her career and environmental advocacy around. Pattie accused the company of using its corporate resources against an individual creator and activist. She argued that the lawsuit represents a larger imbalance of power between major corporations and independent voices. In her statement, she emphasized that losing the ability to use her name would have a significant impact on her work, public presence, and environmental campaigns. The controversy has quickly gained attention online, with supporters debating whether the case is about trademark protection or freedom of expression. As public discussion grows, many people are watching closely to see how the legal dispute develops and what it could mean for activists, creators, and brands in similar situations. The conflict began after Pattie Gonia sought trademark protection for her drag name. In response, Patagonia filed a lawsuit arguing that her branding could create confusion between her activities and the well-known outdoor clothing company. Court filings reportedly include examples of stickers and imagery that resemble the Patagonia logo. The company argues that similarities between the names and branding could mislead consumers into believing there is an official connection or endorsement. Pattie strongly disputes those claims. She says the stickers highlighted in the lawsuit were created by fans and were never sold through her own channels. She also noted that she has already expressed willingness to stop using any parody version of the company's logo if necessary. Another key part of her defense focuses on the origin of the name itself. Pattie points out that Patagonia is a geographic region in South America and existed centuries before the clothing company was founded. She argues that her stage name draws inspiration from that region and not from the apparel brand. As the dispute continues, both sides remain firm in their positions, turning the case into a closely watched legal and cultural debate. While criticism has mounted online, Patagonia insists the lawsuit is not intended to target activism or personal identity. In a public statement, the company said it has a responsibility to defend its trademark because the brand represents decades of environmental work, community involvement, and consumer trust. The company emphasized that protecting its intellectual property is essential to maintaining its reputation and ensuring it can continue its mission in the future. According to Patagonia, trademark enforcement is a standard business obligation rather than a personal attack on any individual. Patagonia also rejected suggestions that it is seeking financial gain from the lawsuit. The company stated that its goal is not to profit from the legal action or silence advocacy efforts. Instead, it argues that it must prevent situations that could potentially confuse consumers about affiliations or endorsements. Despite those explanations, Pattie Gonia and many supporters remain unconvinced. They argue that even if only $1 in damages is requested, the legal costs and potential loss of her name carry serious consequences. For now, the dispute highlights a growing tension between trademark protection, creative expression, and activism. As the case moves forward, it is likely to remain a topic of intense discussion among legal experts, environmental advocates, and supporters on both sides.